our second panel is about the freedom of information, transparency, and the 2025 legislative session. And we'll talk about it all, including what happened in the last session, including why we're looking to do certain things now and the battles that took place last year and what we can hope for in the coming year. We have a rock star panel that I'm thrilled to introduce. And if you look in your program, you'll see that I'm not as attractive and as smart as Josh Hinkle. I was hoping to just play that off, but I'm Arif Panju. I'm on the board of the FOIFT, and I'm one of the managing attorneys at the Institute for Justice. And I'm thrilled to serve on the board with Laura and a lot of other board members that are here today. And it's great to have such a great turnout of folks committed to open government and transparency and doing the work that opens the blinds and tells the stories that helps people hold government accountable. To my left is Laura Prather. Laura Prather is a partner at Haynes & Boone. She's an internationally recognized advocate for freedom of expression. She's certified in civil appellate law. I've heard her oral arguments in the Fifth Circuit. She's excellent. She represents clients in First Amendment cases, anti-SLAPP, intellectual property disputes. She also serves with the Texas Association of Broadcasters Legislative Task Force. She also serves at the FOIFT. She's general counsel for the Texas Press Association's Legislative Advisory Committee and co-chairs the FOIFT's Legislative Committee with me. And she's a great mentor of mine because she got me on that thing over a decade ago. And she's committed to longstanding reforms even across the country and recently started the Media Law Resource Center State Legislative Committee to work on these issues across the country, and was recently named a Fulbright Scholar because she doesn't just do it in the US, she does it elsewhere. Laura Prather. I'll ask everyone to hold their applause until the end. Bill Aylshire. Bill is if you're in Austin, you've heard his name. He's a solo practitioner in Austin at Aylshire Law PC, and his litigation focuses on government accountability and public policy matters. But like all good lawyers, he's also an advocate for change. When he's in court, his cases span everything from constitutional challenges to trying to get TPIA and TOMA enforced so that its promise stays true, and using the courts to do that. But even more than that, in the early 1970s, he also was instrumental. He worked in a staff position in the Texas Legislature as one of the assistants to the House representative for the Texas Open Records Act, which is now the TPIA. And while he was there, he was a member of the so-called Dirty 30, and also served in the Texas Senate as a staffer. I'd love to hear some of those stories, Bill. And like I said, he has seen a lot, and I think will bring great wisdom to bear in today's discussion. But he was also an elected county judge for many years for Travis County from 1987 to 1998, and also served several years under State Comptroller Bob Bullock. And like Lori, he's a graduate of the UT Longhorns Law School.
Look on this year. My God.
Now, not to be outdone, because she's excellent, is Linda Pavlik. Now, Linda, you did go to University of Oklahoma School of Journalism, but you've done all your good work here in Texas, it seems, and done great impact. Linda Pavlik is an open government advocate and was an award-winning investigative reporter at the Fort Worth Star-Telegram before starting her own public relations consultancy in Fort Worth in 1983. And she and her firm and associates focus on strategic communications, media relations, and then public involvement where they represent clients in both public and corporate sectors all across the state. She is a past president of the Tarrant County League of Women Voters and currently serves as the vice president of advocacy. And she continues to manage the state league's open government portfolio before the Texas Legislature. Not an easy place to do that. The League of Women Voters of Texas is one of nearly 24 members of the Sunshine Coalition, and she'll be talking more about that. And like I mentioned, I graduated from University of Oklahoma School of Journalism. It's great to have all three of them. Well, let's jump right into it. There's a lot going on in the legislature. Laura, you've been in the midst of it. There are things that took place last session that informed this session, but also great ideas to kind of jump into this session. So can you give us a sense of some of the legislative priorities that the FOIFT has championed and why we're championing them, and kind of give us the lay of the land of what we can expect?
Sure, I'd be happy to. So, for those of y'all that were here last year, one of the big accomplishments of the last session was closing off that dead suspect loophole. We had a very impactful panel last conference that talked about the impact of this loophole that had been in the law for years and our attempts to go back to the legislature 4 different times to get it closed off. And that loophole had allowed law enforcement officials to essentially not provide access to information if the investigation did not result in deferred adjudication or a conviction. And so think of Uvalde and other circumstances where the shooter was killed, and then there is the ability for law enforcement to just close down access to that information. Now, that law was changed, but it took 4 sessions to do so. And I bring that up both to give you an update on the Uvalde situation, which is we have had to fight that in the courts, and we've been able to get some of the records uncovered. The city of Uvalde has disclosed the records that they had, but everything else is being challenged through the court system. That case we've won on summary judgment, and now the Department of Public Safety, the Uvalde Sheriff's Department, and the Uvalde ISD have all appealed those wins. So it's still locked up in the court system, but for the city of Uvalde, who has disclosed those records. Now, the reason it's important to bring that up is because it helps to exemplify the importance of staying resilient on these issues. The parents of Graham Dyer came and they talked about coming and testifying 4 times about the death of their son who had been tased mercilessly by the Mesquite Police Department. It is that resilience that everyone in this room needs to demonstrate this session as we bring forward a number of the measures that we have been fighting for over and over and over again. So very seldom do we end up passing a law the first time that we try. For those of y'all that have been around, reporter's privilege took us 3 sessions to get passed. Anti-SLAPP, we got past the first time out of the box, but we've been defending it ever since. So staying vigilant, staying resilient, super important for everyone to understand. So this session, I guess I'll start with some of the repeat items in light of that message. And those are our continuing attempt to reopen what used to be the ability to have dates of birth be available. And the reason it is important to have dates of birth available if you are submitting a TPIA request is so that you can verify who you are talking about is the correct person. And in fact, we're seeing more AI litigation where they aren't able to affirmatively figure out if it's the right person. And so you have folks that are renters that are getting denied their rental application because the AI got it wrong. And the AI got it wrong because they didn't have access to the information to verify it, right? You have lawsuits involving the Allen Outlet Mall shooter. The Allen Outlet Mall shooter was shot in the process of all of this happening, and yet a different man with the same name, his image is out there in the media and was misidentified. Dates of birth could have prevented that from happening, right? So the issue here is an issue of foreclosing misinformation and disinformation by being able to verify correctly that you're talking about the right person. And that's something that is a repeat effort. Chairman Todd Hunter in the House has worked on this with us for several sessions. In fact, he has been able to get it passed out of the House before. Senator Kirk Watson, when he was in the Senate, was able to get it out of the Senate. We've just never been able to get it out of both chambers at the same time. So that is one of our repeat efforts that we will be bringing back this session. Another repeat effort is something as simple as codifying the Attorney General Handbook, which says if you have a document in a certain format, you should produce it in that format. And that is basically trying to get at the fact that you have people who submit Public Information Act requests for Excel spreadsheets or database information that are getting it in PDFs that is not searchable and sortable. And so without having that information searchable and sortable, it is virtually impossible to be able to determine if different categories are being complied with, right? And that data journalism is what drives our journalism more and more these days. And it is incredibly important to be able to have data journalism in a manner in which you know what your government is doing so that you can determine and have checks and balances on your government. You can't do that with a PDF that you can't search. So this is an effort that we have tried at a couple of times. We'll be trying at it again this session. Senator Judith Saffarini, who I'm sure all of you are familiar with and who is just a tireless worker at the legislature, will be leading that charge. And then another effort, and this just sounds silly, but it's really not, because it's becoming an increasing problem, is the requirement to have a governmental entity actually respond to your Public Information Act requests. And, I think that shouldn't have to be written into the law, because it really is just a matter of good customer service. But we're hearing more and more, and Kelly in particular is hearing more and more from the citizens of Texas through the complaint line at the FOIFT, that people's TPI requests are getting filed in the trash can. They're not being responded to at all. And even if they are being responded to, there's no effort that's being made to actually meet and confer, pick up the phone and call the requester and say, I'm not quite sure I understand what you're asking for, or there are certain things that need to be redacted here. Are you okay with that? Prior to just kicking it up to the Attorney General's office. So we hear a lot about the Attorney General's office being overloaded with requests for rulings, and so many of those could be prevented just by a simple phone call or a communication or some sort of outreach prior to taking that next step, if the requester and the governmental entity were communicating. So this kind of Ms. Manners bill, respond, meet and confer, this is another one of these efforts that we're trying to get implemented into law, hopefully to help with the workload at the Attorney General's office and to help with the overarching goal of getting the information out to the requester as quickly as possible. So those are a few of the carryover items. We've got some other items. Our Sunshine Coalition that Linda will be talking about more has really wanted us to focus on making the TPIA more user-friendly. So we have some bills that are aimed at that, just making it easier for the average citizen to navigate the Texas Public Information Act. And then we also have enforcement problems. I think all of you know that one of the biggest problems with the Public Information Act is if the governmental entity does not comply with it, there's very little teeth to the law. And the courts have actually eroded that as well. And Bill's going to talk about that a little bit. So we have a few initiatives that I can talk about a little bit later that deal with the user friendliness and with the enforcement aspects of it. But I'm going to let somebody else say something now.
Great. As you're thinking about questions, we'll have some Q&A at the very end. So keep them in the front of your mind. Melinda, since the Sunshine Coalition came up, let me turn to you. As Laura said, sometimes you can push something through right away, like anti-SLAPP. That also required a big coalition. But sometimes it takes a lot more work and multiple years of work. So can you speak to, both some of the examples of the open government problems and how they affect the general public, like in real ways, and why it's important to address some of those through something like the Sunshine Coalition. So take it away.
Certainly. Well, let me say that I'm representing the League of Women Voters of Texas today, Now, the League of Women Voters is much more than just a group that's advocating for the right to vote. We have various sectors that we're heavily involved with. Of course, those sectors will end up relating to the bigger picture of what we're talking about today in legislation. It may be education, it's certainly health, public health, and specifically what we're talking about here, open government. Before I talk much more, I'd like to say that I want to call out the names of the various Sunshine Coalition members who I understand are joining us today, and appreciate so much that what they are doing, what we're all doing together. Representatives of these folks, of these associations, et cetera, are with us. Texas Association of Broadcasters, Texas Press Association, Institute for Justice, SMU School of Law First Amendment Clinic, FIRED, that's the Foundation for Individual Rights and Expression, and publicdata.com. If I miss anyone, apologize. Come shake my hand a little bit later. Thanks to Laura and her team's efforts and organizational capabilities, we're able to hopefully stay on track and move a little faster. I'm a former investigative and political writer. I did that back in the day when people liked us as investigative reporters. And I can't tell you how much information I received that I would be in jail today if I was, given the stories I was writing. The dark of the night at the VA hospital, here's someone, a doctor who meets me, at the local gas station and gives me the health records for this veteran who had been abused, released prematurely, murdered people in Antigua, created a national storm. But we wrote the story and we freed him from the prison there in Antigua. But the flip side of that is that doctor would be in jail at that point if we'd had these sorts of things, because of course it kind of sorted out. I could go on in those regards, but police, oh my gosh, we've already heard about police. I wrote a story that ended up having a federal and state grand jury. Yeah, I'm very young. I'm walking around with protective detail. They're demanding, and I'm working at Fort Worth Star-Telegram. They're demanding my sources. Never gave them up. Things were changed, but I think in today's world, I would be in jail being represented by the Freedom of Information folks. So it is getting worse. I want to just quickly mention a few things that come to mind. It's more than just journalism that open records and those issues are impacting. For example, let me back up. I'm a strategic communications consultant. What does that mean? I'm out there trying to help both public, private sector folks do the right thing, explain their positions, stay out of jail, build coalitions, and work together. So I filed an open records request with a city to obtain a proposal submitted by another consultant who had been retained in the public eye for professional services with city dollars. The city secretary's office would not provide that copy of that document and the proposal, even if the fees and sensitive information had been redacted, and referred the request to the AG's office without providing information. And they wouldn't tell us why. That was 10 months ago. We check in every month. You think we've gotten a response? No. The city secretary in another location has told me that campaign contribution and expense reports of current council members have been taken off the city's website. Office would not provide those records, said that they cannot do so any longer. Though, of course, being the reporter that I am, I have accessed those records through a friend, a staffer of a city council member. But, that's ridiculous, and that's where it should be. And that kind of spills into that date of birth issue. No longer, the date of birth for any person who files for public office has been redacted. You can't get it, period. this is amazing to me too. Just last week, the Fort Worth League hit a solid brick wall. For decades, we have published what we call a voter's guide, and you've seen it. Now we're online. We give every candidate for office, state, federal, and within our area, and et cetera, an opportunity to answer questions, and then go ahead and give us a statement about why they're running. We don't edit those or anything else. Well, I'm not doing this, but our team, our volunteers are doing it. And we've reached out to in local races, to cities and the school districts. And we've been told that they can give us no information on how to contact these individuals. No phone number, no email, nothing. Now, we're talking about, cities like Benbrook and Tarrant County. We're talking about progressive cities, and not even, in my opinion, the communities that are totally taken over by some of our Christian nationalist friends. I know we're recording that, but this is okay. So we could go on. We talked about colleges, for example, and students and being able to publicly protest or speak out and such. Just yesterday, we had a 4.5-hour public hearing prior to a Tarrant County Commissioner's vote, and the commissioner was pushing hard to relist where the voting locations would be. He wanted the educational institutions, University of Texas at Arlington, the community college district locations, taken off of that list for early voting. Why? Because, and he was quoted as this, because that was just being pushed hard by the Democrats so that Democrats could outvote the Republicans. And he said that publicly. So what happened yesterday, there was a number of 4.5 hours of public hearing. Imagine people with three minutes to speak. How many people we saw? I was listening to it online. I don't participate in those things, just from a standpoint of staying, in the background and helping support these initiatives. But the judge was almost hell-bent to make sure the students were quiet. If they even acted like they were going to say the wrong thing or be accusatory or anything, it was kind of like, that's not what we can do here. Sit down, take your seat. If you're not taking your seat, I understand that 4 or 5 people were actually issued out of the chambers. So that's where we're going. Just interested in what we're saying today and learning more.
On your voter's guide, I'm just curious, without a date of birth and without an address, how do you verify that the candidate for office meets the requirements for candidacy from a residency standpoint or an age? You don't.
That's an issue that I have seen in the last several years. And we're not talking about just one jurisdiction. It's all over North Texas. And part of my professional world is researching and understanding who's doing what where. That's the old news reporter in me too. But from a standpoint, we can't. The only reason we will have those names, these jurisdictions will go ahead and put online the names of the candidates, but that's all we can get.
Which is obviously a problem if you have a common name, right? If you have a common name, or just if you want to find out, does the person live in the district that they're representing, or does the person meet the requirements that they need to meet? And one thing I want to follow up on with what you said, and Linda recognized the Sunshine Coalition folks that are represented here, but that coalition, and the reason that coalitions are so incredibly important at the legislature is they show that transparency and open government is not a right or a left side issue. Good government is a citizenry issue, and it's something that our Sunshine Coalition, I think, helps to demonstrate because we have ACLU as a part of it, and we have Texas Public Policy Foundation as a part of it. We have Americans for Prosperity as a part of it, and we have Public Citizen as a part of it. And if any of your organizations here are passionate about and feel like they would like to be involved in the fight for open government and transparency, please come see me or Arif or Kelly or somebody after this about joining the Sunshine Coalition, because the louder and the broader our voices are, the more we can make a difference at the legislature. And the same thing holds true for the prior discussion on anti-SLAPP. I know we were talking about how SLAPP laws are going to be, the anti-SLAPP law is going to be under assault again. We have a different coalition, the Protect Free Speech Coalition, that we've pulled together with more than 620 members and individuals to fight to help keep the anti-SLAPP law intact. That too is in need of additional amplified voices. So please keep that in mind as well as you're sort of thinking through the issues from today and how you want to become involved.
I want to talk about TOMA, but before I do, Bill, I want to bring you into the TPIA conversation. Because you have a unique perspective, and maybe you can weigh in on a couple things. One is that one of the issues that kind of reveals how far afield we've gotten with the TPIA since its original enactment is that, if you think about it, you should want more transparency when some citizen in a jurisdiction says, my constitutional rights are being violated, I'm going to sue the government. And when they sue over a constitutional violation, and it appears that this is more widespread, once open records requests come in from maybe interested media or citizens, the government is very quick to just pick up the lawsuit and waive it and say, oh, we have a litigation exception to the Open Records Act, we've been sued, no documents. And that seems kind of weird because you'd want more transparency if some citizens have taken it all the way to the court. And so that's the one thing. And the other thing is that if I'm reading the TPIA correctly from the very top, it seems that we are entitled to complete information, that it's one of the few laws that is framed to benefit the individual. The government has to justify the deprivation of information, much like our constitutional rights under the Texas Constitution. And so you were there at the very beginning. So can you touch upon both of those things? Because I'm wondering if the sense of the legislature that passed this in the 70s could have foreseen these issues, or what the sense was, if it reflected really what we read when we start reading the TPIA.
If you start reading the TPIA, the first section is what some people refer to as a preamble for it, and it lays out that concept that the government works for the people, not the other way around. The people get to decide what information they demand from their government, because it goes to the fundamental heart of the ability to control and hold accountable your government. If you can't get information about what they're really doing, our democracy doesn't work the way it's supposed to. And yeah, I was there in the room where it happened, so to speak. In 1972, there was probably the biggest turnover in the Texas legislature, I guess, we've ever seen. It was after the Sharpstown bank scandal, where a guy named Sharp wanted to get his bank out from under national regulation. He wanted to have state regulation. He got a bill passed in under cloudy circumstances, so to speak. Some people got indicted and over all that. And there was a group of people led by Lane Denton from Waco and Tom Moore and Sissy Farenthold. I had the pleasure of working in both of her campaigns in 72 and 74. A real mentor. But in 73, there was a reform effort with a lot of political support and push behind it. And one of the things we got passed was what was then called the Texas Open Records Act. And I tease about what Lane's office was down in the basement. It was room G57. We call it the bowels of the Capitol. And we, the very first draft of the Texas Open Records Act came off of my IBM Selectric typewriter with the little correction key on it. I thought that was pretty fancy that it'd go back. And, but I wrote that preamble. I took the best I could find of other laws in other states, and it was supposed to be an inspiration, and it's supposed to be what courts use to understand the perspective for that act. I really worry about the way the TPIA doesn't work. I want to talk a little bit about TOMA as well, the Open Meetings Act, because we're having a hard time getting it enforced. But with you mentioned the litigation exception, section 552.103. I have an idea for a 3-word bill, 4-word bill. Section 552.103 is repealed. Just repeal it. It makes no sense to say that in the circumstances where there's something so controversial going on in government, that the government is likely to be sued or has been sued to shut down all information available to the general public, not just to the parties. And at the time that was put in the act, it was from state agencies saying, well, these lawyers out there, they'll go use the Public Information Act instead of waiting and using discovery later. Okay, it happens. I do it. But so what? And how can, and you're not just going to shut it down for the litigants, you're going to shut it down for everybody. And the most controversial things that go on are things that are going to end up in that legal process. And the government not ever get sued. They just might reasonably think they're going to. And that information stays frozen out there. And reporters that have submitted open records requests, or citizens or others, may never know that there's a provision in the bill that says that if the information is shared in discovery with the other side, then the litigation exception no longer applies. But how will you ever know? You're not a party to the case. How will you know that that information was already provided to the other side and the litigation exception doesn't apply? And by the way, your old request is too bad because the litigation exception applied at that time. You've got to submit another request. So I'd like to see that gone. One of the worst things, I now volunteer on the hotline for FOIFT, and it's a rewarding experience. Any attorneys out there, I encourage you to join us. It's a lot of fun. But I get a perspective on it as a result from all over the state. One of the biggest things I'm seeing is that governmental bodies simply want to delay release of the embarrassing information. Delay is a high value for some of the worst attitudes that some people have in government. They're not all like that. There are governmental bodies that are quick and good and really understand their role in terms of the need for transparency. But the act says they must promptly supply the public information. And we even got the definition, of the judicial definition of promptly incorporated into the act. It doesn't make any difference. It's not enforceable. One other little point I make to you, you want the most expensive, trying to get public information, you've got several obstacles to get over, including bad faith requests for clarification of your request that starts the 10-day clock over again every time they do some thing like that. But the most expensive part of getting records is having to redact the email addresses of members of the public. And now what I've seen happen is that these public officials that are using their personal email accounts to conduct public business claim that their email address cannot be divulged, because that section makes those email addresses confidential. The criminal offense to release those email addresses. Well, I got a third court of appeals opinion they need to read for the Austin Bulldog versus Lee Leffingwell, who was the mayor at a time we caught the Austin City Council members using their personal email accounts as one of the means by which they always discussed what was coming up on the next meeting of there was a walking quorum violation. That holding was that the email addresses of public officials that are being used for official business, they are not members of the public. And therefore, those email addresses must be divulged. If I can, I'll go to Toma.
Yeah, so let's go
Oh,
to,
wait, whoa.
But that's in the Court
before
of
we
Appeals
turn
right
to
now?
Toma.
No, it's already,
It's resolved. Okay, I didn't
we
understand.
won.
Okay,
We won.
thank
They
you.
didn't appeal.
For clarifying.
Before I ask Bill about Toma, let's stick on TPIA for a second.
I
Or
have
jump in.
Yeah, I have a couple of things here. Number one, thank you for the preamble. That's awesome. Didn't know you wrote it. Fantastic. Number two, I had an IBM Selectric too. I saved up all my babysitting money for it. I thought it rocked as well. It's fantastic. Number three, on the litigation exception, I'm just wondering, okay, if you use that pre-litigation, right, to get information, does it ever convince you not to file a suit? Does it ever
Yes.
actually? So
Absolutely.
in some sense, this is actually a benefit if you're able to get the information, because it doesn't end up then clogging up the court system with needless lawsuits.
That's right.
There's your argument.
And it seems like it shouldn't matter to the government if you get information that's public by default under the TPIA, because you might find something that reveals their unconstitutional behavior. But it seems that that's where we're at. Linda, anything on TPIA you want to jump in on
We're
litigation
fine.
exception? Okay, I'm going to turn back to some enforcement issues in a second. But let's talk about Toma. Bill, there's several examples of ways that it needs to be improved. And it seems like the common theme with Toma as well is that it's almost as if you've got to kind of claw the transparency back, where, whether it's agendas or packet materials at council, and then there's a remedies problem. So can you jump into Toma and tell us, what
Yeah.
kind of a surgery needs to be taken in place on that statute?
I have a perspective that a lot of practicing lawyers in this area don't, because I've had to comply with the Open Meetings Act as county judge. And every week get that agenda out there with a fair public notice. I'm proud to say in 12 years serving as Travis County judge, I never got sued once for the agenda item, not explaining what we were actually doing. But again, you don't have to worry so much about the words in the law if you've got the right attitude by your elected officials. And we've got an attitude problem out there with way too many officials, elected or unelected. I want to draw you back to a perspective. It's kind of like the preamble for TPIA and its purpose, but think about what the Open Meetings Act does. It is really, try to think of any other law that is so baked into how governmental bodies have to make decisions and deliberate. It is unique in the sense that every meeting they have, there are certain fundamental things about public notice, public involvement, openness in their discussion. I used to hear a lot of complaints. In fact, after that Leffingwell case, I heard a lot of complaints. Well, we can't ever get anything done on the city council if we can't ever talk to each other in secret. Well, and Kirk Watson got a bill passed that helps with that, and it's the messaging board, where you can all the council members can talk with each other on a website, and everybody gets to see it, and they're not violating the Open Meetings Act by that. That's a practical solution, but I get it. I know it's not always easy to keep things going, but it's going back to the room where it happens. The thing about the Open Meetings Act is that it tells citizens, you have a right to be in the room when it happens. And not only that, before you get to that room, you're going to know what's going to be discussed in that room where it happens. And, by the way, you no longer have to just sit there like a stump watching the meeting. Under 551.007, you have a right to speak on the items that are on that agenda. Now, we've had some really interesting cases this year involving the city of Austin. Both of them is one, they decided that you'd have 3 minutes, but if there's 4 agenda items you want to talk about, you only get 3 minutes. And they lost that in court. They had to come back because the act says you get a reasonable amount of time to speak on each agenda item. And so that case with SOS versus City of Austin, the trial court judgment handed down in early August. Well, then what did they do? They took 13 charter amendments and put them all together in one agenda item. So if you wanted to, it's like, do you never? This is Kirk Watson, is mayor. Do you not put your agenda together where people get a reasonable amount of time? And so they got sued over that. But this time, this is a big important case that we just won at temporary injunction on, because they did not put out the notice of any kind of description of each of those 13 charter amendments in the meeting notice. Their vote to call that election for those charter amendments was declared void by the court. I had 2 district judges both go the same way on this. And Judge Gary Gamble said, this was so flagrant that it appears it had to be intentional. A lot of those charter amendments are self-serving, the members of the city council, making it harder to get recalled, for example. So let's keep that perspective in mind. But let me just real quickly, I'm going to give you just 3 or 4 examples of problems that we've had that we thought we were going to get addressed. But one, the Austin City Council passed an ordinance or created a PUD, a planned unit development. And in that ordinance, though, was buried a multi-million-dollar exemption from water tap fees for Pilot Knob. That was the subdivision. And when we found that out, in danger of bankrupting the Austin water system, it was already having financial problems. And when we found that out, we sued them. And one of the things that the council didn't even realize it, and one of the council members wrote an email to the city manager, Mark Ott, at the time, and said, why didn't we have a fiscal note on that? And Mark said, well, in reading the agenda wording, I didn't realize that there would be a financial impact. That became the lead sentence in my lawsuit. The city manager didn't realize it, and that was the public. We had the Lake Austin Collective. They had an agenda item saying they were amending a settlement with a development over by the Champion Tracks in West Austin, and included in it was an exemption from the Lake Austin Watershed Ordinance and the Hill Country Roadway Ordinance, 2 important environmental provisions that they were waiving for this development. We sued over that. Austin appealed and lost on appeal for that. And with this history, you would think you talk about bipartisan. I mean, God love Republican Todd Hunter. You know, it's not just Republicans. The stereotypes about transparency being partisan is just wrong. There are villains and heroes on both sides of that, believe me. I've seen it. And one last thing, let me also say that one of the things that I have seen happen, and I've been involved in them, you can see a clear violation of the Open Meetings Act. Be pretty certain as a lawyer you're going to prevail in that case. But then you have to tell your client, before I file this TOMA suit, I got to tell you that there's an attorney fee shift provision in it where you could become liable for the government's attorney's fees if a court wants to award. That's unlike TPIA, which is all one-sided. The plaintiff either gets attorney's fees, nobody does. But in a TOMA suit, it's scary. And I've seen violations go unpunished because they were too afraid of doing that, being in that position. I had a case, it was called TOMA Integrity versus the Windermere Oaks Water Supply Corporation. That Water Supply Corporation is subject specifically to the Open Meetings Act. They had a board that sold a few acres, I think 4 or 5 acres of very valuable property. This is in Burnett County, and they have a subdivision where you can fly your plane in and park your plane at your house. And so these airplane lots are very, very valuable. Sold it to a board member for a fraction of what the market value was, with no competition. When my clients came to me and said, I can't believe they've done this, it was about a year later, the deed transaction had already been done. And I looked at it and I said, well, wait a minute, there's nothing on the agenda for that December 20th meeting about this at all. And then I look at the minutes, and in the minutes, they say they went to executive session to talk about this, and in their minutes said that they had approved the sale. Clear violation. And then they did the same thing that was in December. In February, they did the closing, and they had another TOMA violation. I went to district court, and the judge said, you're right, absolute clear violation, but we're not going to do anything. The deed's already been done. We're not going to undo it. I appealed. It got transferred from Austin to Texarkana for workload purposes. The Texarkana judge in that opinion, TOMA Integrity versus Windermere, it decided that we hadn't brought the case soon enough. Had not brought the case soon enough. That the act is there to get quick action. But if they do something secretive and you don't find out about it for a while, now you're gonna be in a position where you can't enforce it. There's another case where the Harker Heights condominiums versus City of Harker Heights, there was a board, like a board of adjustments, and they had a provision in their city code that said that if you lose there and you appeal to district court, you have to do it within 30 days. They did not appeal that in 30 days. It was like 45 or 60 days. But their claim was that the board had violated the Open Meetings Act, and they were seeking to undo the action because they'd not posted it correctly. Both went to the Supreme Court. Court said, too bad. Should have brought that TOMA case within that 30-day period of time. So one of the things that we've talked about is the need to make clear what is the statute of limitations in TOMA. It does not have any provision in it. There's case law saying that it defaults to the standard 4-year, but we're seeing all kinds of exceptions to that. So practitioner beware.
Enforcement is a real issue, and both with TOMA, with remedies, and with the TPIA, of course, we want courts to bend the power to be able to check and balance the other branches for not complying or for passing things that are absurd, or when they're not absurd, like the TPIA. So there's an enforcement mechanism. So let me bring Laura.
May I ask
and
a
Linda.
quick question?
Yeah.
So the plaintiffs in these cases, how would you identify, especially the one on the land there at the airport?
Well, what we did on those TOMA cases, in fact, 2 of my cases here, the individuals were very afraid of what might happen on.
I don't really care. So that piece, yeah, and making it public. But what I don't, okay, were they folks at odds? Were they?
Okay.
There's another side to that story, and
Okay.
I'm just
Yeah.
curious. I own an airplane hangar, okay, and there is an association, but I'm curious about how that bubbled up, and how long did it take to bubble up?
The Water Supply Corporation was having a real hard time making ends meet, and they kept raising the water fees. And my clients are all residents and fee payers of the Water Supply Corporation, but they were afraid to be on the hook. So they created Toma Integrity Nonprofit Corporation, and that was our plaintiff. And the same thing was true in the Champion Tract development deal. Those are all residents that lived next door to the development that was going to go on, and they created Lake Austin Coalition, Inc., so that they could.
Did that activity take a year, 2 years, 7 years?
The Toma case took,
To get to your point where you file a suit?
we filed suit on Toma. It was over a year before they realized what it was and then came to me. It was like the transaction had already occurred a year and a half before. And so by the time they come to me and I look at it, I said, well, we'll file suit as soon as we can, but boy, we got burned on that.
No. Well, the question that I've got, okay, because I'm out and about, Palo Pinto County, water, mineral wells, every rural county has serious water issues now. There's conversation and et cetera about filing suit. I respect these folks that they're worried, all their various bills are going up. But I'm thinking, as especially in the type of engagement that we are involved with, is letting people know. They were concerned about their water bills. Were they angry at the water board? Was there political strife that, from a water board position and election standpoint? There's so much of that behind the scenes. We can talk about it later.
Well,
I think that, to me, I'm not a lawyer, but I want to understand the background. Your high-level thinking is fantastic, but in my opinion, that sort of action needed to occur sooner. There needed to be more practical reason. Again, was there political strife between the elected officials? Let's talk about it later.
But the motivation for plaintiffs doesn't have to be anything more than they wanted the transparency, and they wanted, regardless of what was going on in that specific case, they want to try to persuade that governmental body not to do that again. But one of the other wonderful features of the Open Meetings Act is who has standing to bring the case.
I want to cover
Any
the news
interested
story, though. I want to cover the news story as it goes forward. But let's talk about it later. Thanks.
This is a good discussion because it's driving at enforcement. And the TPIA is not just for lawyers, it's for everyone. In fact, there's more people use it that aren't lawyers. And so why shouldn't they be able to enforce it in a meaningful way? Just the same that lawyers can do it, perhaps in a more sophisticated way using courts. And so with enforcement, there's all sorts of issues swirling, Laura. And one of them is, there's different aspects to it. Bill hits one of them, associational standing. You can pool together, you have associational standing, you can go to court and seek redress. Another one is fees. If the government's got to pay fees because it's nonsense on the front end, gets exposed in court, that's a deterrent. So there's things about enforcement that work together. And so maybe we can
They have to pay fees under the TPIA unless they moot it by finally giving you the information after you've already
That's
sued.
right. So a lot of gamesmanship that's at play. And that, at the end of the day, takes the air out of the enforcement balloon. And so how do we get to this? How do we get enforcement to a place that it's better? And is there anything federal that's happened that maybe signals to the path forward here in Texas? Maybe we can spend a couple minutes on that, and then we'll open up to questions.
Okay. Fees. So fees is not the only way to have an enforcement mechanism in place, but that is probably the most effective way. We have actually gotten a fees bill passed in Texas before. The impetus for that fees bill was exactly what Bill described, where we have seen over and over in the court system that even if you are a citizen who actually has the wherewithal and the means and the lawyer to file a lawsuit, and that lawsuit ultimately results in the governmental entity producing the materials that you've requested, at that point in time, they can then say to the court, the issue is moot, and the court no longer has the ability to award the fees. This was happening on the federal level. It is something that under the Federal Freedom of Information Act, under FOIA, they fixed. They changed the law more than a decade ago. So we went in 2017 to try to mirror that change in Texas and have basically the same changes they made in federal FOIA done to TPIA. Representative Smithy got that law passed for us, and Governor Abbott vetoed it. It's the only time I've had a law vetoed. I can tell you exactly where I was when I found out. It's one of those moments.
I respect what you're talking about,
Yeah.
and I've pushed it a little bit too far. What I'm wanting to come out of these conversations ongoing with the Sunshine Coalition, with the League, is there are ways to help educate the folks about their rights and where they can go. They don't have to wait for 2 years or 4 years to hire an attorney and face those complications.
Totally agree.
And understanding it early on, and I think that's part of where we are as,
That's the hotline.
Yeah.
well,
So
where we are as journalists too, in understanding that.
So let's talk about a couple of ways that we're coming at it in light of the prior veto. And I'm not giving up on just trying to reform it and make it into a FOIA system. But another way to come at this, and I'm going to start with the court system, but then I'm going to go backwards, okay? In the court system, if we can get the ability to file a declaratory judgment where the courts are able to say, this is a TOMA violation, this is a TPIA violation, and under the declaratory judgment statute, this happens all the time. Did this or is this not a violation of the law? And the fee award is discretionary. And so in that instance, you still have the ability or the threat of fees to be able to hopefully deter bad actors, intentional bad actors. And believe me, they are not all bad actors. In fact, I'm looking at Ruth, who is in the room, who works at the comptroller's office, and Ruth and the comptroller's office are shining examples of good actors in this space. Yes. So I really don't want to paint this as, government bad, citizens good, because that's not how it is. But
There's some crazy citizens that misuse
oh
the
my
act.
gosh, and then we hear about
And they
that
try to
and have to
retain
deal
me.
with that. And so yes, it's on both sides. But let's back this up. So declaratory judgment would be a wonderful approach where there would be a discretionary fee shift and a pretty efficient mechanism for the courts to decide, are the laws being violated or are they not? So that is one of the bills that we will be promoting this session. I hope all of y'all will support that. But even before that, we're trying to, and I mentioned earlier, the Sunshine Coalition is very much interested in making the TPIA more user-friendly. And the way in which we want to do that, and a few things that we've talked about doing that would help before going to court, because nobody wants to have to hire Bill. Bill's a great guy.
Bill's trying to retire. I
But
don't
yeah,
know if he can-
but Bill wants to
Sick
retire.
and Tired of having to sue them.
And for
But
every one
I
of-
have to sue them.
Look, for every one of Bill's lawsuits, I end up having to go over to the legislature and try to get the law passed. So we need to figure out a better system. But in doing that, so we have three different approaches to what I would call user-friendly bills. One is to codify the Attorney General hotline. Okay, FOIFT has a hotline. It's remarkable. Y'all should use it. People like Bill, myself, Reed Pillifant, who's in the room, Tom Williams, Tom Leatherberry, and others man this hotline, and you get a whole lot of knowledge for a goose egg of a price. But it's also helpful that the Attorney General's office used to have in place a hotline system where you could call them and you could file a complaint dealing with the costs that were being assessed, a complaint dealing with the tactics that were being taken. That system has become very opaque in recent history. It is no longer as obvious or apparent that it even exists. So one of our bills is codifying that system that has been in place and making that a statutory requirement. The second is training. This gentleman over here just showed me an incredible video before I walked up here where the city attorney was giving wrong advice to the city council in his hometown about videotaping city council meetings. And the sheer need for training of our public officials and training of their legal counsel is something that we don't have legal counsel having to be trained. So if you can require those legal counsel to be trained in the TPIA and in TOMA, that too is something that hopefully could help on the front end. And then finally, the third option here or proposal to make this more user-friendly and more cost-effective is the ability for a requester to request mediation with the governmental entity before kicking this up to the Attorney General's office. And that way you force a conversation. It's kind of like that meet and confer requirement. You force a conversation and you use those underused SOA judges who exist throughout the state of Texas. And you have them step into the role of mediator to be able to help facilitate a resolution in these cases or circumstances without having to face the daunting task of hiring an attorney and incurring those sorts of fees. So those are the three sort of user-friendly mechanisms that we're talking about. The declaratory judgment is an enforcement mechanism, but it's one that is much more cost-effective. It is streamlined in the court system, and it does provide that opening for fees.
Let's take a few questions. We've got just a little bit under 10 minutes. There's plenty of time. And I'll repeat the questions so that, well, you'll all be hearing the question, but I'm repeating it so that our recording will also include it. So let's start with one right here to my right. So the question is, TPIA, TOMA, these are civil statutes that are often, that often when litigation arises, you end up involved in civil litigation. And is there like a regulatory mechanism that can help enforce the bad acts that are taking place on the governmental side? And also, shouldn't non-compliance by the government bleed into criminal violations?
Yeah.
And I'll open it to the panel on that.
Both of the acts have criminal provisions in them. Of course, now you've got to get the county attorney to bring suit against the county commissioner's court or the school district or the city. It's a misdemeanor. But like with TPIA, there's offsetting provisions. There's one makes it a criminal offense to release confidential information. On the other hand, it also makes it a criminal offense to deny public information without having even asked for advice from a lawyer or gone and gotten your AG ruling on it. On open meetings, on behalf of the Austin Bulldog, who I've volunteered as an attorney for many years, one of those investigative online
Read it all
things
the
that
time.
she's Ken Martin really is a journalist. And, but when we discovered the email traffic, my client was Brian Rogers, who was going to run for the Austin City Council, and he went and asked Chris Riley, who was on the council, what's your week like? What's it like? And then he described in detail how on Mondays they start their 2-on-1 and 1-on-1 meetings with the mayor, and talk about what's coming up on council, and then they all it's kabuki theater by the time they get to the council meeting because they've already rehearsed everything and had these backroom discussions with each other. We turned that evidence over to the county attorney. It was David Escamilla at the time. It took him 2 years to do the investigation, but he used subpoena power. He went after all their email accounts, their phone accounts, and all that, put together a package, and all 7 members of the Austin City Council will put on 2 years prosecutorial probation because they had gotten caught with probably one of the clearest examples of the walking quorum you could ever get. So there is the way to do it, but you're right. It's the main force of this is civil litigation, and it's a shame. It's too bad when I look out there and see both government attorneys as well as public officials, elected officials, whose attitude about this is that, the citizens are just a bunch of pests and they need to be bypassed, and we just need to get out there and get things done and stop all this foolishness of having people give us input.
So the question is, Article 1, Section 10 of the Texas Constitution guarantees open access to courts and remedies by due course of law. So is there kind of an implication that the Texas Constitution can bring to bear vis-a-vis TOMA? Does it rise to the level of a substantive restriction that violates that provision, really? Is the
I don't
part
know
of the
how
question.
there'd be a waiver of sovereign immunity without those statutes. Is that you can have open courts all day long, but if you don't have a cause of action that's allowed to get around sovereign immunity or official immunity, what does it do? So those statutes are what get you in the door to the courthouse.
Immunity is the issue then?
Huh?
Do I understand you said that immunity is the issue and that that's the issue that you can get that?
I think without them, they would claim you can't sue the king.
So then you can either go through common law doctrines of immunity to try to create ways to get at the heart of the constitutional question, or you can have statutes that can be meaningfully enforced. And those are affirmative pronunciations by the legislature that say, this is the law, government, and this is what you're going to have to comply with. It's a great question. I think also that there might be some places to mine in the petitioning clause, which is way different in Texas than it is in the U.S. Constitution. It has a rich history, great substantive rights.
And the free speech, Texas free speech.
Free speech, yeah. So the state constitutions are great. There are 51 constitutions in this country, and state constitutions are framed to restrict plenary power and to ensure that you have a working government. So it's really a good question.
Dave Montgomery asked, what are some of the egregious examples we could probably all have of governmental bodies delaying getting out information? I don't know. Mayor Nelson, can I talk about the city of Bastrop and the city secretary? Or anyway, yeah, it's just I see it way too often. They'll wait 10 days and ask you for some silly clarification, and then now they've got 10 more days. I mean, it's just and the other one is they'll throw in the 10-day letter asking for an AG ruling with every exception there is. They're just buying time and until they really have to face the music that they may not even have a good grounds for withholding the information.
They'll ask you to pay.
Oh, I'm sorry.
No, I mean, we've got one where they'll ask you to pay for costs, and then after you pay for the costs, then they seek an AG opinion. So they've already delayed it by asking for a clarification. You provided the clarification, then they provided a cost letter, you provided the money for the costs, and then they've sought an AG opinion.
Cost abuse is another one that they use
Yeah,
to delay.
absolutely.
I'm sure some, I'm sure that a lot of them might like a good fight effort, but did they just kind of hope that wear you down?
It's, I mean, it's hard to get in the mind of somebody else, but there is certainly, to the extent that you've got a news organization that's dealing with a hot issue and something where they need the information quickly, or else the news cycle is going to pass. There's that element that comes into play, no doubt, because, if you can delay the information coming out, then perhaps the issue at hand will no longer be newsworthy.
Sometimes when I'm not sure what's there and I'm wondering if is that just smoke or is there fire there? And they start behaving that way, I know. They're worried.
There's battles ahead, and that, yeah,
Well
as
said.
Laura emphasized, it's important to be resilient, and also, if I could add, to seize opportunities. And so, we've laid out a lot of issues and talked about them, but it really takes everyone to bring everything to bear, because that's the only way it's going to work, to keep pushing at the problem until it's fixed and not feel like the headwinds are a reason to walk away or back up. It's a
Just
reason
do
to
your
move
part.
forward.
Just do your part.
That's right. So thank you, and please join me to give a hand to Laura, Bill, and Linda.